Hello, and thank you for joining us for the SLW Coffee Break webinar, Patenting AI Using AI, Espresso Edition. We will be recording the webinar today and sending a link to the recording and slides to everyone who has registered. We will also put a link into the chat to where the presentation slides are posted online. If you would like to ask a question, you can enter questions using the Q&A feature in the Zoom menu or in the chat. Our speakers today will be Nathan Elder, Lucas Jelly, and Andre Murray. Today, we will be discussing from invention disclosure to AI-focused drafting, prosecution and enforcement strategy for AI patents, and AI analysis and quality checks. And with that, I'll turn things over to Nathan.
Hi, I'm Nathan Elder. I'm a patent attorney in our Minneapolis office, and I do a lot of work with a variety of clients, and most recently focusing heavily on AI. And Michelle, if you want to take us to the next slide. So artificial intelligence is reshaping industries at a pace that we have never seen before. And I wanted to share just three examples of things that have happened recently that kind of drive this point home. So a company called Anthropic in January of this year released a product called Claude Cowork, which is similar to another product they have called Claude Code. And they actually used Claude Code, which is an AI tool, to create the product in 10 days with just four people. Another recent tech-related product where AI is involved is something called OpenClaw. So a single person on a weekend project, Peter Steinberger, created this agent that has gone viral, and everybody is installing it. Peter ended up at OpenAI, and anyway, it's a fun project if you haven't played with it. If that's your thing, I highly recommend you try. And just yesterday, Anthropic posted a blog post about how their models are now working with COBOL. COBOL is an old mainframe programming language that even predates my education engineering days. But based on this blog post alone, IBM's market cap went down $31 billion. So if you can take us to the next slide. So the reason I bring these things up is because these are examples of how things are changing in the marketplace, and specifically the development of software and AI. And so things are happening at a pace we've kind of never had to deal with before. And so from an IP perspective, this creates some problems in the sense that we don't have a lot of time to necessarily work through a traditional IP workflow. If you do invent something and go public with it very quickly, vibe coding, uh, you may find that 10 days later you have, 10 knockoffs. So in the case of OpenClaw, there's a variety of like cloned projects now that are similar to the original. And so I will take this time to remind everybody of the 102 bar date. So if your product goes public, you have 1 year from that public disclosure to file a patent application in the US. And you may have less time. The what constitutes public disclosure differs in other jurisdictions, but a lot of other jurisdictions are absolute novelty jurisdictions, so you don't get that 1 year grace period. So given this, what can we do? And this is particularly, I guess, useful for like solo inventors and smaller companies, but even larger companies can take some of this to heart here. So one strategy is to use the very same AI tools that people are using to create software to create invention disclosures. So as an example, Claude Code is a command line interface tool that people use. And if you haven't used it before, it's very much like ChatGPT, where you have a conversation with the model and create a plan first, and then you have the tool essentially create the code that goes with that plan. And so one idea is to actually have your model, prompt your model to sort of take notes about anything that might be innovative, and that way you can very quickly hand those over to a patent attorney. So another idea here is the idea of filing provisionals. Um, we can file a provisional very quickly. You can iterate on your idea, file a second provisional. The idea being that then you would, within that 1 year time frame, pull all of those provisionals together and file a non-provisional. Next slide, please. So the first thing I do when I get an invention disclosure that has to do with AI is I kind of have my own mental framework for, classifying what type of invention it is. And so this kind of represents that. On the left, I have what I think of as an invention that improves the AI or some part of AI itself. This is actually a lot of different things that it could be: model architecture, training algorithm, inference optimization. There's a wide variety of things that might be. But in that category, the invention is actually sort of the technology of AI itself that's being improved in some way. And the second one is what I think of as using AI as a component in solving some other problem. So you might have an application that, predicts fraud or a recommendation engine, and you're replacing some existing component with an AI component. And anyway, that's another class of invention. The third one is when we use AI to actually help with the innovative process itself. I'll be honest, this is not an area that I have seen very many disclosures. I suspect people in our firm have, but this is not an area that I work on. This is drug discovery is an example, material science. And on the bottom here, I just have a quick chart to explain sort of, depending on the category, you face different challenges. So the first category is probably the easiest from a one-on-one perspective. Whereas the other two categories are definitely more difficult. That doesn't mean that it can't be done, but you definitely have to think through the strategy a little bit more. Um, Next slide, please. So with respect to 101, one of the challenges we face is that the language we use to describe machine learning and artificial intelligence, it kind of mirrors the language we use to describe what people do. And so you can see a couple of examples here. And I will say that this is an area where I think opinions probably vary. I do have clients that have provided guidance suggesting that we steer away from some of this language. I personally, given that this is the language that technical people, the experts use, I tend to use this language as well. I think then you just have to make sure when you're drafting that you provide examples or provide definitions so that it's clear that when you're talking about, how a machine learns, what that actually means. And so one of the things you can do, and I'll probably hit on this more in the next slide, but you can actually use AI. You can prompt your model to, you know, to provide that definition. So if you're reading your, patent application that's almost complete and you come across these words, you might prompt your model to, for example, improve a paragraph or two by providing some additional detail or definition to avoid having certain terms interpreted as mental processes. The probably the most straightforward path to circumvent or prevent getting a 101 rejection is the what we call one of the considerations is that you want the specification to explain a technical problem and a technical solution to that problem, and then you want your claim to reflect that. And so this is an area where I think, particularly in interviewing inventors, you need to be careful. Inventors tend to have the probably human nature, by human nature, they want to explain the invention as some advantage that results to the end user. And that's probably the easier way to understand an invention often. But you need to recognize that when you're, interviewing an inventor and sort of push back and ask the right questions to make sure that you're capturing, what the technical problem and technical solution is. I like to think of it as that gap between how does the prior art solve the problem and how are we solving it differently and what are the advantages in doing it our way versus the prior art. So that's probably your easiest way to get over a 101 or to prevent a 101 rejection in the first place. Um, Next slide, please. So another problem with another challenge, I should say, with AI inventions is that you have a lot of words that do not have well settled meaning. And what I mean by that is a large language model is perhaps a good example of that. So we frequently are drafting claims that might involve a large language model, and it's not clear to me anyway that there is a precise definition of what large means. My understanding is the number of parameters in the model dictates whether it's a large model versus a medium model. But I try to identify those kinds of words and then use a broader, more conceptual word when appropriate. But what I'm mentally thinking about when I'm drafting an application with these concepts that are kind of in flux, if you will, is I'm trying to think of this like inverted pyramid where I describe something conceptually, and then I want to provide additional technical detail and then finally, very specific examples of what that is intended to mean. And one thing you can do is again use your AI tool to help in this respect. One prompt that I really like for improving the quality of a patent application, and so when I'm reviewing my final draft, I may think that, a real world use case or an example would drive home the understanding, particularly maybe for the examiner or something. And so I will prompt a model to, I'll maybe give it as context a few paragraphs and say, draft a real world use case that's, easy to understand and drives home the point. And this is actually something that I've found that the AI tools do very well. Next slide, please. So before I hand it over to my colleague, I just wanted to touch on two real-world prosecution problems here. So as I kind of mentioned, we are, it seems like drinking water from a fire hose when it comes to AI and technology. It seems like every day something new is happening and things are definitely evolving and changing very fast. And so what I found is that not only are we having problems keeping up, the examiners do as well. And so I have got two cases here that I just wanted to touch on. So I had a case where I had a claim that recited a transformer encoder. And in my specification, I had some detail about what that meant. And for those that don't know, a transformer is a type of model architecture that was first introduced in 2017 in a white paper with the title Attention is All You Need. And so when I got the prior art rejection, I noticed that the prior art predated the publication of the white paper. And so I thought to myself right away, I was like, how can this possibly anticipate or render obvious the idea of a transformer encoder when the prior art reference predates the invention of the transformer encoder? And so through an examiner interview, I was able to sort of explain this to the examiner and overcome the rejection. But another, so I guess the lesson there is that if you're dealing with an examiner and you do need to educate the interview process is obviously, I would highly advise, for AI inventions where you've got complicated subject matter, definitely have an examiner interview. Another tool that I just recently came across and used. So I had another case that dealt with an AI invention, and it addressed a very specific problem that occurs with LLMs. And I had a 101 rejection, And right around the time I was trying to come up with a response, I actually came across an article that directly addressed the problem. It basically was I believe it was a blog posting that directly addressed the very same technical problem that occurs with LLMs. And it even discussed a couple of different solutions to the problem. And so I was able to submit that as evidence in a 132 declaration. And the nice thing here was is that the article, it was not prior art because it was published after our filing date, but the good thing is that it was used as evidence to establish the fact that everyone recognizes this as a technical problem and that there are alternative solutions to the one that my inventors had actually claimed. So, and shortly after that, the director actually put out some guidance suggesting exactly this as a strategy, basically suggesting that subject matter eligibility declarations are underused and should be used to introduce evidence for 101 rejections. And with that, I will hand it over to my colleague Lucas. So thank you.
Thank you, Nathan. My name is Lucas Jelly. I'm also an attorney here in the Minneapolis office. I work in electrical and computer engineering arts, and lately that has involved a lot of AI inventions. So we've been drafting and prosecuting applications for a while, and there's been some recent changes to the laws. So we'll talk through that, focusing on prosecution for my section here, section 2. Next slide, please. Some of the recent clarifications are, we've had some recent clarifications. However, even with those clarifications, all the eligibility analysis and our response remains fairly examiner-driven and fact-specific. As Nathan mentioned, it's a great idea to talk with the examiner sometimes about the different responses, because the practical reality is the outcomes typically vary a lot by examiner, even with the updated guidance. However, the updated guidance does provide us with a great framework, so we'll talk about that here in the next few slides. Some of the recent shifts in the eligibility, the subject matter eligibility determinations, include the mental process analysis, modifications to the analysis for that, and then increased emphasis on the improvement analysis under step 2A, prong 2. And we'll dive into that in greater detail because that tends to be more effective. Again, a takeaway throughout the entire presentation, but certainly my section, is that overcoming these rejections depends a lot on the improvement narrative in the specification, and then making sure that that's drafted, the improvement is also reflected in the claims. Next slide, please. So under step 2A, prong 1, we found that a lot of the rejections tend to be based on alleged mathematical concepts or mental processes. The recent August 2025 memo constrained the mental processes somewhat to cover limitations that cannot practically be performed in the human mind. That memo also tried to distinguish claims that do not recite a judicial exception, and that should be a shortcut framework. So when you're responding to a 101 rejection, some of these amendment tactics and remark tactics include the amending your independent claims to avoid a recitation of mathematical concepts. It's important to note that a claim can involve math without actually reciting this mathematical concept, and that's what you're aiming for. You want to try to clarify any mental process cannot be performed practically in the human mind, and then also to argue that the claims do not recite a judicial exception. Now, on that last point, we found that even though the memo and the analysis suggests that should be the end of it, that if it doesn't recite a judicial exception, that should end the analysis, and the claim should be determined to be subject matter eligible. We found that that doesn't always carry the day. So under step 2A, prong 1, we found it more effective to argue the mental process prong, where it cannot practically be performed in the human mind. It's a good idea to include both arguments, but we found the mental process to be a bit more effective. For most of these, the analysis tends to turn on prong 2. Next slide, please. So step 2A, prong 2 is where we've had the most significant change. The recent decision, Ex parte Desjardins, is particularly important. In Desjardins, it's important because it confirms that the improvements to the model itself can be enough. in Desjardins, they had trained a model to mitigate this catastrophic forgetting, and that specific improvement was held to integrate the idea into a practical application. Desjardins had very specific improvements indicated in the specification, including reduced storage, reduced complexity, and preservation of performance across tasks. So when drafting your application or prosecuting it, you're looking for specific features, specific improvements that relate to the operation of the model, the functionality of the model. And they should be more than just result oriented, just a general assertion of improving efficiency. Instead, it should be more directed to how the model operates, a change in the model operation, or how a specific model feature enables the improved, the reduced storage, reduced complexity, et cetera. And then you want to ensure that the claims recite those features or the technical features that enable those improvements. So those two features, the specification description and the claims recitation. In the Desjardins decision indicated that examiners have to evaluate both of those, the improvement in the specification and the specific claim limitations that provide that improvement. Next slide, please. So the MPEP will be updated to clarify this analysis. Again, the spec, the examiner is to look in the specification for enough detail for the person of ordinary skill in the art to recognize this improvement, and then to look to the claim to confirm that it recites components or steps that provide the corresponding improvement. So under prosecution for responding to one-on-one rejections and in drafting the application, you make sure that the specification specifies this model operation or the specific improvement, and try to clarify these specific improvements. Like Nate mentioned, whereas the inventors will often tell you how it helps the end user, that's helpful too, but the specification we need to ensure describes everything that comes before that, all of the changes to the model operation, the quality improvements provided by the operation, or tie those improvements to the specific model architecture, or maybe they're tied to the way the training parameters for that model are updated or used again in a subsequent training, but they must be specific to that architecture of the model or the model's operation. After the specification recites those features, you ensure that the claims recite the specific mechanism that provides that improvement. You want to avoid, again, the general aspirational language about how it helps the end user. Avoid any conclusory statements about general efficiency improvements and focus on the specific technical features that are improved. And then keep in mind that any improvement statements not only help you in these 101 rejections, but also, of course, help overcoming ART for 102, 103, where your invention provides a better solution. Next slide, please. So the MPEP example 47 provides a high-level framework of some features that you might see in rejections. The two examples it provides are a claim 2 that included all of algorithmic training, math, mental processes, AI tool usage, and insignificant extra solution activity. They contrasted that with claim 3, in which the ANN output triggered a system control action. So there was some change made as a result of it, or a control of the system provided based on this output. So you can recite some of the features in claim 2 if you need to. There, sometimes we'll have some other features that are just part of the claim, but you must ensure that it focuses on that AI architecture. So it's good to keep these two claims in mind when you're looking at drafting your claim or amending your claim to avoid some of those features there in example 47 claim 2. Next slide. And to wrap up my section here, if there's one takeaway, it's that the eligibility of AI inventions is largely narrative driven. You want to make sure that the improvement story you tell in the specification is solid, and then that's reflected in the claims. So when responding here under prong 1, it's good to either amend your claims, draft them as to avoid these features, or to amend them to avoid these features, avoid mathematical framing, and then to recite features that cannot be performed mentally. Prong 2, you want to make sure to anchor your eligibility arguments and claim amendments in the technical improvement to the AI model or system operation. During prosecution, it's good to analogize to examples, example 47, or Desjardins, or EnFish in the responses and during the interviews. And then ensure that your improvement narrative, that the specific features that are specific to your AI model are captured in the specification and then reflected in the claims, and that helps you across 101, 102, and 103. And with that, that concludes the prosecution portion. I'll hand it over to Andre to discuss AI analysis and quality checks.
Yeah, hi. Well, thanks, Lucas. Appreciate that, and Nate also. Yeah, so I'm a partner in our Silicon Valley office over here, and have also, working a lot with AI-related inventions. But both Lucas and Nate and myself, we've actually been quite involved in developing some of our own internal AI capabilities to really give effect to, I think, what Lucas and Nate have talked about above. But so I think I'm just going to give a brief overview of what we're seeing and where we're focusing and some of the challenges. So we can go to the next slide. So I think as you would have discerned from both Nate and Lucas, for AI-focused inventions, they do have this elevated legal risk under 101, but also under broad functional claims and also distributed system architectures. I think the thing that our attorneys we're finding is that the traditional budgets that we're kind of operating under typically we're not sized to really accommodate the amount of work both in the drafting and the prosecution phase to fully address and enable us to craft applications that are of high quality. I think patent attorneys across the board were doing a good job, but I think there's always been with the USPTO and the Federal Circuit, just the increased level of scrutiny has put a lot of pressure on the profession. But I think the good news is that to a certain extent, AI tools have and are coming a little to the rescue there and helping patent prosecutors really achieve a very high quality of drafting and also prosecution at each of the stages that we've talked about, during both the drafting and the prosecution stage. I did want to point out that we're getting a lot of comments like, oh, is AI enabling you to cut costs? And certainly there are efficiencies that are achieved in certain areas, but as we found, we've kind of injected the quality review and built quality improvement functions into our drafting and prosecution processes. The story is not really a cost saving. It's more of an enablement story. It's enabling us to do stuff that previously would have been extremely challenging to do. And to a certain extent as well, when AI presents you with a lot of options, it takes time for the attorney to actually review all of those and figure out what to do and which ones to follow. So at the end of the day, I think the takeaway here is that I think AI can really enable patent attorneys to produce higher quality patent applications. When I mean higher quality, I mean more likely to be successfully navigated through the patent office and also withstand Federal Circuit litigation, or even so I think that kind of comes from Nate's discussion, really, where the surfacing of technical solutions, technical problems during the drafting phase really when you draft the application, that is really the foundation on which all of this rests. And I think everything he highlighted over there is valid. Michelle, sorry, I think we're running out of time here, so I'm just going to quickly skip through the drafting and the prosecution. I'd maybe just encourage everyone to kind of look at these slides. I've kind of identified there where we are actually finding AI assisted or drafting to really be helping our attorneys position and craft applications that can well withstand subject matter eligibility and other scrutiny. Yeah, Michelle, so maybe you can advance to the prosecution as well. Each of these slides is kind of a slightly different focus as to where we've built or we are building checks and assistance into our AI tools to help our attorneys. I'd just like to quickly skip to the last one, which is really this enforcement readiness checker. And this was actually, we actually kind of built this out internally responsive to a client request. And this is really to take a look at issued patents and really do a kind of a deep dive into, would this patent withstand subject matter eligibility and other scrutiny, at the federal circuit, or in, broadly in litigation. And I think the use case here was really both for assessing the enforceability of, owned patents, but also for doing a risk assessment against threat patents that were being, threatened against them. And we've actually found that AI can very quickly, with the right prompting and with the right resources, actually, get our attorneys to a position where they can actually do this, enforcement readiness report fairly quickly. The output at the moment we have is kind of a SWOT analysis, which gives, the strengths, weaknesses, opportunities, and threats with respect to a particular patent, and I think gives people a very balanced view of the risk profile for that a particular patent may have or may present. Michelle, so the last slide. Yep. So I think the point I made earlier, I think AI surfaces a lot of the issue. It takes attorney judgment to resolve these, and it takes real time, and that's by design. But certainly, I do think AI assisted drafting and AI assisted quality checks and reviews built into the process from cradle to grave can really deliver much stronger patents that are more likely to withstand prosecution and litigation scrutiny. Okay, we're at time, so I maybe just wanted to give opportunities for any Q&As or any questions. I think we have some questions in the chat that are out there. We could maybe address those. I think the first question is, where do we get copies of the slides for the presentation? I think those will be circulated and made available afterwards. The next question, and Lucas and Nate, maybe you guys want to think about this. How are examiners with limited review time able to appreciate well-enabled AI-drafted patent applications? So basically just asking how examiners, with their very limited time, are handling basically examination of these applications. Any thoughts on that front?
Yeah, that's where I think examiner interviews are particularly helpful. And I mean, that's just part of what we do on a daily basis, is trying to, both tell the story in a patent application, but then, I mean, you get that first office action and you kind of have a sense whether the examiner gets it or not. And with a more complicated AI invention, I definitely want to have that examiner interview, not only to feel out the examiner, but to educate the examiner and in a humble way. I frequently start out with, yeah, I didn't get this either, but now I do, and here I am to help you. And so it's part of the storytelling process, I guess.
I'd maybe add to that as well that the USPTO has various initiatives underway to also deploy AI tools to assist the examiners in the examination process. So I think we'll be seeing a lot more of that. And I mean, to a certain extent, I think we are seeing some office actions that it's clear that maybe the examiners have used AI assistants to do that. So I think that might be one thing that initiative that the USPTO, I know they have that underway. Yeah. Okay. Well, if you want to hang around, we do have, we do have one more question here. I think it's from Jessica Tai. She's asking, at what point in the division of labor between an inventor and an LLM should AI be considered as a co-inventor? So I think that's we could have probably a whole webinar on that topic itself. But I don't know, Lucas, Nate.
Well, I will say the short answer is at no point, in the sense
Yes.
that we just got some pretty strong guidance that suggests that, well, I mean, it's always been the case that you can't list the LLM as an inventor. So to rephrase the question, I guess the question might be better asked, at what point is the inventor an actual inventor versus the LLM? Because and the point I'm trying to make is you can't list the LLM as an inventor, and that's definitely an area to keep an eye on. And I know that there's some guidance out there, or I guess the guidance that was out there has kind of been overturned or overruled, if you will. But it is a good question, and I don't have an answer for it exactly. One answer is whether the inventor is willing to sign a declaration to suggest that he invented it. I kind of think of it as the LLM is a tool, just like a calculator is a tool. And so, it really depends on the facts of the situation, I would say. But I don't know that there is a bright line rule that we can quote at the moment.
Yes, yeah. To add to that, it's intuitive. It makes sense to think about the AI contribution. If it's a large contribution from AI, then there may be some AI inventorship, but that isn't the framework that we use. The correct framework is, if there's a human conception of this claimed invention, then that's human inventorship, and that ends the analysis. Whether there's an AI contribution is, at least under US law now, is generally legally irrelevant. So focus on the human conception of the claimed invention, and then make sure to document that. If you would like, you could even document which inventors contributed to which claims. But in any case, if there's human conception, that's the primary analysis.
Yeah, and I think the Kim memo that you previously referenced, Nate, in your presentation from August 4, 2025, basically does talk about this, the close call rule, where it's borderline whether the human's contribution was significant or not. So I think, as you correctly point out, it's a bit of a maybe an assessment of, was the human's contribution significant or not. And that comes kind of down to problem formulation, who formulated the problem, and then was there prompting to get the AI to go in a certain direction towards the solution, and what do those prompts look like, and to what degree was the system prompted, and did those prompts have suggestions, or were they really open-ended? But definitely something that definitely something to keep an eye on. Yeah. Okay. Great. Okay, Michelle, well, I think that's it from the questions. I'll hand it over to you to wrap up.
Sure, thank you. Thank you for joining us, everyone, and thank you to our speakers. Please keep an eye out for future SLW Institute webinars. Take care.